Do you own the rights of things that were created by someone who you hired as a contractor or maybe an employee? Particularly if what they created was the logo that you use for your business? Check out this current case related to Marvel and their copyrights to learn a little bit more. If you don't currently follow me, I'm Attorney Jones, an intellectual property attorney who helps small businesses and entrepreneurs protect their brands by teaching you about hot topics and current cases. So for the second or third time now, there is litigation related to the use of the Marvel characters. Now, let me be honest, I'm not a Marvel fan. Don't hate me. But I do understand the value and the high dollar signs related to each and every one of the Marvel comic book characters. Some changes in copyright law has made it so that the descendants of the original copyright owners, that is, the people who created some of these characters, is kind of up in the air. So this litigation goes back several years. But here's what the important question of the case involves. The courts have to determine whether or not these Marvel characters, their likeness, their storylines were works for hire. Under copyright law, whoever creates a work of art, a drawing, a painting, a poem, is the copyright owner as soon as that work of art is put into a tangible form. But an exception to that is works made for hire. Works made for hire are things that were created by what is essentially, but not technically, employees. So if someone worked for your business and they created your logo as a part of their assignment, you pay their normal salary, you're in control of their schedule, it's probably, in most cases, a work for hire. But if a person is considered a contractor, that means that you pay them outside of normal 9-to-5 work. You may have hired them to create this one thing or several pieces of art for the purposes of use by your company. Then the person who you paid as an independent contractor may be the copyright owner of your logo or whatever else they created for you. While that copyright owner can give you exclusive use to use that copyright as you so wish, if you don't have an official copyright release in writing granting you full ownership and use of that copyright, you may not even own your own logo. Will that stop you from getting a trademark? Not necessarily, but it's not worth the risk. Check the comments for a link to a free copyright release form.